Hello everyone, this is Tom Fox and I would like to welcome you to episode 145 of the FCPA Compliance and Ethics Report. Today I conclude my look at SEC enforcement of the FCPA in part 2 of this series. I take a look at the issues around the strict liability enforcement of the FCPA and the potential for profit disgorgement based upon the strict liability finding. The episode comes in at just over 20 minutes. I hope you enjoy it. Thank you. Hello everyone, this is Tom Fox and I would like to welcome you to this episode of the FCPA Compliance and Ethics Report. Last week I did an episode on the Securities and Exchange Commission's enforcement of the FCPA, part 1, and today I wanted to do a second part because I want to take some of the things that I learned and see if I can put them together in a way that may present to you some new or different ideas about how the SEC may move forward regarding enforcement under the FCPA. And I'd like to focus specifically on internal controls. I should first note that my good friend Mike Volkov is doing an interesting series on internal controls, the SEC and the FCPA, this week on his blog, so I would encourage you to go over and check it out. Corruption, Crime, and Compliance is his blog site. But with that, recently the Director of Enforcement, Andrew Serezny, the SEC Director of Enforcement, gave a speech at the CBI Pharmaceutical Compliance Conference in Washington. And he had several very interesting remarks around compliance, self-reporting, some of the corruption schemes that the SEC has seen in the pharmaceutical industry. But I wanted to focus on his thoughts on internal controls because I found that he had some really interesting remarks. Now, he said that they were in the context of financial reporting. However, I found that they really could and should and will have significant implications for the compliance practitioner going forward. I thought one of the most important things he said was that internal control problems have been prominently featured in recent enforcement cases we have brought in the financial reporting area, even in cases without accompanying charges of fraud. This reflects our view, and our being the SEC's view, that adequate internal controls are the building blocks for accurate financial reporting and can prevent fraudulent activity going forward. As I said, this specific remarks, or these remarks, were around financial reporting, Sarbanes-Oxley, SOX 30, sections 302 and 404. But I think this really portends directly to what the SEC is thinking about regarding its enforcement of the FCPA, specifically around internal controls. Because the key in this phrase was that they brought a number of cases without accompanying charges of fraud. So I think this is a clear enunciation from the Director of Enforcement that strict liability is here, and it's probably here to stay, and it's here to stay in the FCPA area. But he made some other remarks I'd like to go into. He also said that his key takeaway is that senior leadership of companies should place strong emphasis on the importance of designing and implementing strong internal controls. Senior leaders need to ask questions about what they are being told about their internal controls, and perhaps more importantly, what they're not being told about them. Dropping these occasional inquiries into conversations where they're not expected, Serezny believes, sends a powerful message that you want these issues to be on your employees' minds. And what is needed is not just involvement from the senior leadership, but also from the compliance committee, the audit or compliance committee of the board, instead of a check-the-box mentality. It is important to use careful thought at the outset of how internal controls can be designed in light of the firm's business operations. This entails an upfront assessment of financial reporting risks, designing controls that address those risks, and ensuring that the resulting controls are well documented and communicated. As your company's business evolves and changes, management should and indeed must consider whether the existing internal controls are appropriate or if they need to be enhanced or changed. Appropriate resources and attention also need to be devoted to monitoring those controls for effectiveness and making changes as needed. So every time Seresny says financial, I think if you substitute compliance, you'll see where the SEC is headed towards its enforcement on internal controls. So what I'd now like to turn to, though, is something that I really thought about as I wrote my series on the Securities and Exchange Commission, and really where I think the next level or next series of enforcement actions are going to go. So as I mentioned, I was particularly struck by Seresny's comments that in the area of financial reporting, he said that internal controls have been prominently featured in recent enforcement cases where we have brought in the financial reporting area, even in cases without accompanying charges of fraud. That sounds to me exactly like strict liability. And where I think the SEC is going, certainly in the realm of FCPA enforcement, is for strict liability under the internal controls provisions. So what can you do? How do you get to this strict liability? Well, the first place to go is to the text of the statute itself. And here, after reading and rereading both the Foreign Corrupt Practices Act and commentary, I believe there's no tie or link between the accounting provisions, of which internal controls is one, in addition to books and records, and the offer or the payment of a bribe. So based on this, I believe that strict liability interpretation for the enforcement of the FCPA is fully supported by the plain language of the statute itself. This is really based on that there is no language in the text that ties the accounting provisions to any other operative violation of the statute itself. So while the FCPA does not specifically say that a company will be strictly liable for a violation of accounting provisions, it's certainly not prohibited. And based on this, and with Seresny's comments at the recent pharmaceutical compliance conference, that the SEC will bring internal controls enforcement actions in the financial reporting area without evidence of fraud, this is really enough for me to believe that strict liability is not coming, but it's here. Interestingly, one of the major differences between the Department of Justice enforcement of the FCPA and the SEC is in the damage remedy called profit disgorgement. Now, there are other distinctions between DOJ and SEC enforcement. Obviously, there is the civil versus criminal aspect. There is the cease and desist order, which the SEC can get. But profit disgorgement is a remedy that's available to the SEC through a change in an unrelated law. And that unrelated law is called the Penny Stock Reform Act of 1990, which amended the underlying legislation for the Securities and Exchange Commission, or the Securities Act of 1934, to allow the following: impose tiered civil penalties pursuant to administrative findings of violations of the Act, enter an order requiring an accounting and disgorgement, issue cease and desist orders, and issue temporary restraining orders. Now, this expansion of SEC remedies is not limited to the Penny Stock Reform Act enforcement, but it was to the underlying legislation, granting legislation for the SEC. So they can enter these, have these remedies in any type of case that they would enforce, specifically including the FCPA. We also find imposed tiered civil penalties pursuant to administrative findings of the Act. So, administrative findings of violations of the Act. So pretty clearly there is a reference to the administrative process that the SEC is now using. So there may be additional basis for FCPA cases to go through the administrative process, and additional basis, and when I say that, in addition to the Sarbanes-Oxley, Dodd-Frank changes in 2010. But let me focus on profit disgorgement, because profit disgorgement has traditionally been seen as an equitable remedy. And Sasha Cobb and Mark Bone, two lawyers at Miller Chevalier in Washington, in an article called Disgorgement, the Devil You Don't Know, wrote that as an equitable remedy, disgorgement is not intended as a tool to punish, but as a vehicle for preventing unjust enrichment. The SEC, therefore, is only permitted to recover the approximate amount earned from alleged illegal or illicit activities. Disgorgement of anything more would be considered punitive. In another article from the University of Michigan International Journal of Law, David Weiss, an article was entitled Foreign Corrupt Practices Act, SEC Disgorgement of Profits, and the Evolving International Bribery Regime, Weighing Proportionality, Retribution, and Deterrence, said that punishment schemes fail a utilitarian test when the punishment exceeds or threatens to exceed the offense. Put another way, deterrence requires that a punishment will be proportional to the harm, allowing for a multiplier based on the likelihood of being caught. Punishments that are not proportionate are not justified under the utilitarian theory. So what's interesting about this, first of all, I would note that Mr. Weiss is now a assistant U.S. attorney in Philadelphia. Also, he's also from the University of Michigan School of Law, as I am. But so we've got really this underlying tension of what profit disgorgement is. You might even say that profit disgorgement has been traditionally required or used where there are ill-gotten gains. But what happens if we take Serezny's words, that there's enforcement with no evidence of fraud or no evidence of bribes being offered or paid that would violate the FCPA? How about profits disgorgement in that situation? Well, I'm pretty confident that strict liability is here to stay. I'm even more confident that it's not prohibited by the statute. So that brings us to the remedy of profit disgorgement. And if we take the underlying basis from common law of what profit disgorgement is, what it's designed to do, and why it exists, it would seem to be that can only be used where there is unjust enrichment. But what happens if there is no unjust enrichment? What happens if there is no finding of unjust enrichment? What happens if there's no allegation of unjust enrichment? Well, or conversely, what if the SEC says that because your internal controls didn't meet the standards that we set, whether that is COSO 2013 framework or something else, and you can't prove, at least to the SEC satisfaction, that you had robust internal controls, what would be the measure of damages? Would it be simply one of the four remedies that are listed in the Penny Stock Reform Act of 1990 to impose tiered civil money penalties pursuant to administrative findings of violations of the Act? Or would it be profit disgorgement? And if it's profit disgorgement, is it not tied to the traditional common law basis where there must be some unjust enrichment or ill-gotten gain going forward? I would note that I read the reform of the Securities Exchange Act of 1934 directly, and there's nothing that ties a profit disgorgement remedy to its underlying basis or indeed unjust enrichment. So statutorily, that may be enough. But it certainly provides a interesting remedy that the SEC might use going forward. And for companies, it may be extremely difficult to try and defend because of couple of reasons. So in their article, Kalb and Bone also said that because these calculations, and here I mean the calculations for profit disgorgement, like these often prove difficult, courts tend to give the SEC considerable discretion in determining what constitutes an ill-gotten gain by requiring only a reasonable approximation of the profits that are causally connected to the violation. But what happens if there's no court oversight and there is only an administrative SEC enforcement action? Last year, the SEC went undefeated in its administrative enforcement actions, although in the Q1 of 2015, probably in honor of March Madness, they have had one setback in their own administrative process. Nevertheless, that's still a pretty good record. And if you are going towards more, or if the SEC rather is going towards more administrative actions through either the 2010 Dodd-Frank amendments, which enabled the SEC to collect civil penalties through the administrative proceedings, or under the authority of the Penny Stock Reform Act of 1990, there may not be many federal district courts reviews of this going forward. And furthermore, to have a review, you have to have one party's objecting. And to date, the companies, at least in the SEC realm, that have gone through FCPA enforcement in the administrative process have, if not agreed to do so, not objected to the SEC utilizing this mechanism and going through it. So it takes two to tango, and it certainly takes one defendant to make an objection. And most companies seemingly do not wish to take on the SEC or the Department of Justice, for that matter, in an FCPA enforcement action. But even if there was a federal district review of a cease and desist order, you almost never hear of a court rejecting an agreed order because the remedy was too harsh or unwarranted. The times we've had federal judges reject agreed orders and penalties is when the federal judge thought they were too light. And certainly Judge Rakoff has raised this concern. Judge Leon did last year in the IBM SEC enforcement action. So it's going to be interesting to see what his thoughts might be if the recent announcements that IBM has fallen under some other FCPA violations. It's going to be interesting to see what happens in that manner, or in that form. So I recognize that this is a step, beyond where we may be now. But I think it's something that as the compliance practitioner you will certainly need to be aware of, because if there was a profit disgorgement remedy, it could certainly up the cost for strict liability violation of the FCPA. And the thing about the internal controls that has intrigued me is the requirement under SOX 404 of internal controls reporting. So the information is there. It's there for all to see, and it's there for both the SEC to see and the public. And Cerensky even talked about data mining these company reports on the creation and enhancements and functioning of internal controls and what those reports may show. And if the SEC deems them insufficient and renders a company strictly liable, and then they throw on a profit disgorgement, it could become very costly very quickly. So I'm not sure where this all may go, but I think it's certainly a possibility. I think the legal authority is there for the SEC to make some of these intellectual leaps and enforcement theories. So it's going to be very interesting to see which way this goes. I hope you've enjoyed this two-part series on SEC enforcement of the FCPA. I've written about it extensively, so you can check out my blog at the FCPA Compliance and Ethics blog. I'm happy to answer any questions you may have on this. You can contact me at tfox@tfoxlaw.com. This is Tom Fox, and thank you very much for listening.